We're here today, a local attorney, and he's going to be covering estate planning. I picked up from his first session that he has practiced it 37 years.
38, actually. Thank you. Well, today we are going to talk a little bit about some estate planning, general considerations and alternatives, why to do it, and what are some of the alternatives that are available. What I like to do whenever I do remarks on this or other subjects is keep it kind of informal, so if any of you have questions at any point during the discussion we have this morning, please feel free to raise your hand and we'll try to answer them. I don't know, I know this is being taped. I don't have any microphone here, so I assume that if someone asks a question, it'll be picked up all right and will be carried that way, so we won't need to repeat questions. Very good. Okay, well, first of all, thank you all for being here this morning. I think most of you, hopefully all of you, got a copy of the handout that was at the door coming in. If you didn't, I think there are maybe a few extras over there. And that'll sort of be the outline of my remarks this morning, generally speaking. And we'll divert from that as needed if any of you have any questions. It's good to see some familiar faces in the audience this morning and to have a chance to come back here to Trinity. I was telling John Oakley this morning that I was baptized in that baptismal font. I must not be very observant because I had just noticed it was an oak leaf gift to the church. I've got some roots back here. I can remember old Pastor Tilburg. One of the stories Dad used to tell about Tilburg was that if you ever stood next to him at an event where the person was getting particularly long-winded with a prayer, Tilburg would say, "That fellow doesn't give the good Lord credit for thinking of anything." Anyway, so we'll talk a little bit about some estate planning things, and what I'd like to start off with is a few of the reasons why to do estate planning. And probably the most obvious reason that would come to everyone's mind is the importance of making sure that the things you've worked hard for, that you diligently work to acquire during your lifetime, pass as you intend when you pass away. That's a very obvious reason for it, but it sometimes bears emphasizing that if you don't prepare a will or some other estate planning device, the law will do one for you very obligingly, and will pass it as the law presumes you would have intended, which normally would be to spouse and children. If there is a surviving spouse and children, if there is no surviving spouse, then to children. If there are no children, then to surviving spouse. And then from that point on, it becomes nearest of kin. So if you had, for example, any kind of charitable objective, and you didn't have an estate plan in place, those charitable objectives will not be observed. If you had certain members of your family who you might want to leave something to, or who you might want to put some strings on, because of the fact that they might not be the best managers of that property, if you don't have an estate plan, those things won't take effect. So the first and most obvious reason for an estate plan is to make sure that your property passes the way you intended to when you die. Another reason, of course, would be to take care of loved ones when you're gone, to make special provision for them by setting up the sorts of things that you might need to have. For example, we had situations over the years where people might have a child that has a special need, where they had certain things that needed to be done for them with particular attention being given to their needs. There is in Illinois what's referred to as a special needs trust, where you can provide under your will that property can be set up for the benefit, say, of a child that might have those kinds of special needs, without disqualifying them for the public assistance that they might depend on. And those kinds of things can be taken care of by an estate plan. On the other hand, if it passed without a will or a trust to that loved one, it would go without any strings attached. And if that person was on public aid, it might disqualify them from the assistance they were getting if they were in an assisted living community. Another reason might be to avoid taxes. Now, this has become less and less a concern as far as estate taxes are concerned. Most of my remarks today are going to be focused on Illinois, but we practice both in Illinois and Iowa. Illinois does not have any inheritance tax. Iowa does have an inheritance tax. Illinois and Iowa both also have an estate tax. However, Illinois' estate tax currently has a $4 million exemption on it. So if your estate's under $4 million, you don't need to worry about that. And the federal exemption right now is $5.43 million, so it's even larger. So you could have that large an estate without having any kind of estate tax consequences.
You're talking to the wrong group.
I'll bring it more back to reality here. So for most people, estate taxes aren't a big consideration now. Now, if you did fall in the fortunate class of having to worry about those things, you can actually, through some estate planning, get that, if there's a surviving spouse, you can increase that amount up to $8 million in Illinois and $10.8 million in case of the federal. So if that affects you, come see me. But don't make it dependent on that, because there are other tax considerations that are affecting more and more people, particularly income tax considerations, particularly as they relate to tax-deferred plans. Now, for many of our generation and older generations, tax-deferred plans haven't been as big a deal because they had what were called defined benefit or pension plans. Now more and more employers are going to what are called defined contribution plans, 401ks, 403bs, and that sort of thing. And those carry with them some special considerations because with a tax-deferred account, you haven't paid your tax on it yet, right? And so the tax comes when you withdraw the money. And if you withdraw it and you don't have, and it's withdrawn after your date of death by, say, the beneficiary that you designated, there are some devices that you want to make use of to minimize the amount of that tax. And there's some things you want to avoid doing that could really increase that tax. So the tax considerations we're talking about now really aren't so much about estate taxes or inheritance taxes in most instances, particularly for those of us in Illinois, but they're related to income taxes as it relates to tax-deferred accounts. So that's a factor to be thinking about. Other factors, we're here at a church and it's appropriate we should talk about charitable giving. For those of you who are charitably inclined, charitable giving is one of the reasons that you would do estate planning, to make sure that the charities you want to provide for are taken care of, either upon your death, by an appropriate gift that you wanted to make, or even during your lifetime with some things we can talk a little more about if you're interested, of charitable remainder trusts, which is something that allows you, in effect, to keep the value of the property, the benefit of it during your lifetime, and then at death it passes to the charity automatically. So those are some things that can be done. Another reason for estate planning can be for asset management during your lifetime. Suppose you're disabled. You can't take care of things. Estate planning can assist with that, either by using a trust or by a power of attorney. Powers of attorney are a very common instrument, a very simple instrument to prepare. Trusts are a little more complicated. But either of those can assure that you can pick the person who's going to manage your affairs if you're disabled by taking care of yourself, your physical well-being, it's called a health care power of attorney, or your property, what would happen with your property upon your passing. So all these are reasons for those who have younger children, and this may be, in this case, grandchildren, to counsel with your children about doing this. Another reason for using estate planning is to assure that guardians are appointed for minor children, someone that you felt was appropriate to take care of the children until they came of age, who that person would be. And another reason could be for the orderly passing of a business. If there had been a business that had been in the family for a period of time and you wanted to see that it passed to a particular individual, say there were a couple of children and one was involved in the business, we have a client like this now who has one child that's involved in the business and the other is not, and the one that's involved in the business is the one who's going to get the business. But there will be a question of how to ensure some kind of equity for the child that's not in the business as well. So those kinds of things can be addressed. All these are the reasons why it's useful to do estate planning. Now, what are some of the tools that are used? Well, the first one that most people think about, and the one that I always hit on first, every person should have a will. Even if they've got a trust, even if they've got beneficiaries on most of their assets, they should still have a will, because there's probably something that they didn't cover, okay? What is a will? A will is simply a direction by means of which you provide how your property will pass at your death. Now, there are certain legal formalities that you need to comply with in order for a will to be valid, and it's important that you comply with those, otherwise it's an exercise in futility. I'm going to give my first warning today, and there may be a couple of others about mail order wills and mail order trusts. They're usually not worth the paper they're printed on. We've had instances in the past where people have come in with trusts that they've obtained through the mail, and they're 200 pages of garbage. And I've practiced law in the estate planning area for, as I said earlier, for about 38 years, and one of these that came into the office couldn't make sense out of, because it had sections, one section of the trust agreement contradicted another section. This was a trust that had been obtained through California company, and it made reference to community property. We don't even have community property here in Illinois. At other places, it referred to California law, where for people as these folks were, they're Illinois residents, wouldn't have even been relevant. So these mail order things, don't do that. You wouldn't do mail order surgery, you wouldn't have mail order dental work, and don't do mail order legal work. It's really the unauthorized practice of law. But be that as it may, it's out there. And don't be taken advantage of by that, because you're likely to wind up with something that isn't going to accomplish the objectives you intended, might not even be a valid instrument if it isn't done in compliance with law. Yes?
How about a power of attorney? Can that be done with mail orders up?
Well, I wouldn't encourage it. I have a very charry feeling about these things, because some of them might pass muster, but do you want to take a chance that it won't? Do you want to be in a situation where you're disabled and you've got a power of attorney that needs to be used and it doesn't comply with Illinois laws and it's not valid, and now you have to go through a guardianship proceeding? I mean, we'll come to that in a little bit. The guardianship proceedings are definitely to be avoided because they're expensive, they're difficult for the family, they're embarrassing for the person who's disabled because they have to be brought into court and have to have their rights read to them and have to have an attorney guardian ad litem appointed to protect their interests, and have to have a certificate from the doctor and potentially the doctor's testimony. I mean, they've got a lot of safeguards to make sure that people don't take advantage of a disabled adult by a guardianship proceeding, and that all costs money to overcome those barriers, and they can all be avoided by a valid power of attorney. So don't take your chances on any of the documents we're talking about today. They're not that involved to get put together, depending on your estate plan, but they are extremely valuable in terms of the savings that they could, and the loss of aggravation that you could save by avoiding it. So a will is a basic estate planning document, and it basically provides for how your property would pass. Generally in that you want to have a first, second, and third choice of how the property would pass, because the first, we're all mortal. I used to have a professor at Augustana College who said we all run the risk of being the first immortal. He said that sort of laughingly, because I don't think any of us feel that's too high a risk. But the reality is that the person that you may name as your first choice or second choice may not survive you. And if they don't survive you, then you want to have a backup. So you want to do that. You want to consider if there are any specific items you want to have passed to particular people. Maybe there's an heirloom or something that was passed to you by someone that you want to make sure goes to a particular individual. That can be put in the will. One of the things we find pretty commonly we'll put in wills now is a general provision that says, if I leave with my will a list on which I've directed how items of tangible personal property are to pass, each page of which I've signed and dated, to make sure it's yours, not someone else's, and it's with my last will and testament, I direct my executor to give effect to this list in disposing of those items. And that can be useful because you might have a lot of little things that you want to leave to people. They're important to you, but they might change from time to time. You might give some of them away to the person during your lifetime. There might be things that the person passes on, so they're no longer there, so you change the list. You don't need to come and see your attorney every time you change the list. You can just change the list, put it with your will, and you're good to go. Now, if it's something you think they're going to fight about, then put it in the will. I had a case a couple of years ago, I kid you not, where we had a nice couple in the office, and they had two grown daughters. We'll just use the names Julie and Cindy. I don't know what their names were, and I wouldn't share them if I did, but Julie and Cindy, and this couple was preparing their will, and I asked them this question. I said, now, are there any things you think the girls are going to fight over? And they said, they looked at each other kind of sheepishly, and then they said, well, there is one thing. And I said, well, what would that be? They said, well, we got this porcelain pig, and we know the girls are going to fight over it, so we want Julie to have the head of the porcelain pig, and we want Cindy to have the body. So that's in their will. That's in their will. Now, I'm guessing it must have been the cookie jar or something, and the girls fought over that. They had fond memories of the homemade cookies or something, so they both wanted the porcelain pig, and so with the wisdom of Solomon, Mom and Dad split the pig in half, gave them each half of it. But if you've got something like that, yes?
How about an irrevocable trust?
Yeah, we'll come to that in just a minute. We'll talk about revocable and irrevocable trusts. In fact, I'm glad you brought that up because that's a nice segue. I just want to mention one more thing about a will, though. A will, unlike any of the other documents we've got today, is a one-of-a-kind instrument. You can only have one will at a time. When you do a will, usually the first phrase of it will be, hereby revoking any will by me heretofore made. That means any wills you signed before that will are gone. The will that you make is it. And we usually leave it with the client. We don't keep it in our office because we figure it's the client's and they should keep it. But if it can't be found when you died, it's assumed that will was revoked. Because if it was known to be in your possession, the law assumes if it can't be found that you destroyed it and therefore revoked it, which leaves you without a will. So you want to make sure that when you do a will, you do it properly, and then you keep it in a safe place. We had a case a couple years ago involving a woman who had 3 children, two sons and a daughter. The daughter had some disabilities. The mother had set up a special needs trust, like I mentioned earlier, for the benefit of this daughter. When the mother died, she had the will, but when she died, it had disappeared. They couldn't find it. The boys searched high and low, and they couldn't find it. We kept a copy in our offices, we always do, of the instruments, so we had a copy of it. We knew she'd signed it, but there was this legal presumption she'd revoked it because it couldn't be found, and it was last known to be in her possession. So we had the 3 of them come in the office, and we sat them down, and we talked it over. And the daughter had some she wasn't really able to function well on her own, but she was able to understand the nature of what she was doing in general. And she agreed to allow us to probate this will, and we got the will probated. But you've got to be careful of that, because you need to make sure your will is safe and intact. A will is an instrument which only becomes valid when you die. And because there's no one else, you're not there to say whether it's true or false. That's why they have all the formalities of properly executing it and this presumption that says if it can't be found, it will be revoked. So it's an important instrument, it's a valuable instrument, and it's one to be treated accordingly. Now, talk about trusts. Revocable and irrevocable trusts. A revocable trust, which is more common in estate planning, is a trust that you set up during your lifetime that basically controls how your property will be managed during your life and then directs what happens when you die. Okay? They're quite a bit more expensive to set up than a simple will. Because with a revocable trust, and I'll touch on irrevocable in a minute, although that's much more limited, I think. But with a revocable trust, which you can change at any time, just like you can change your will, with a revocable trust, when you set it up, you really need 3 different steps. First of all, you need the trust. Second of all, you need a will, because you still have to have a pour-over. It's called a pour-over will. It just says, if I forgot to put something in the trust, when I die, I want to go into the trust, with a few exceptions. And then the third thing that you need to do is you need to put the property into the trust. Because if you don't put the property into the trust, it covers nothing. Follow me? So if you have some real estate, we've got some clients who have some property down in Florida we just went through this with. We actually contacted an attorney in Florida who prepared the deed, and they transferred the property in Florida, as well as the property they've got in Davenport, into the trust. So now, when one of them dies, you won't have to go through any kind of probate proceeding in Iowa. It'll just pass through the trust directly to the surviving spouse in accordance with the trust that we set up. So that's how trust can work in terms of allowing assets to pass that way. But you have those 3 steps. And because you have those 3 steps, it's a lot more complicated than a simple will, where you keep the property in your own name and you just provide passive debt. Irrevocable trusts are things we start to steer clear of, except in very narrow circumstances. Irrevocable trusts usually work best when you were trying to get rid of some property, get it out of your name for tax reasons. And for the reason we talked about before, that's not as big a consideration. The big problem with irrevocable trusts is that they're irrevocable. You can't change it. Once they're set up, you're stuck with it. And that's not a real good situation because circumstances can change. And if they do change, and you've got it in an irrevocable trust, short of getting the property out of the trust, if you reserve the right to do that, you can't change it, you're stuck with it. So irrevocable trusts are not all that advantageous. Revocable or changeable or amendable trusts can be useful. My general advice to people, we do trusts, and I've done a lot of them, but I'm not as gung-ho as some people are on pushing trusts, because Illinois probate law is a lot simpler than a lot of states. We have what's called independent administration in Illinois, and it's a lot more streamlined process than most states have. For example, Iowa. In Iowa, I'm a big believer in trusts, because their probate law over there is, shall we say, a little bit Byzantine in some respects, in terms of the hoops that you need to jump through. Illinois has it's called independent administration, where you go to court at the beginning of the proceeding, you go to court at the end of the proceeding. You don't have to file an inventory with the court, so nobody finds out what you own. You do have to file a will, obviously, probate the will, but otherwise there's confidentiality as to what you own and your activities as an executor. One of the other advantages to probate in Illinois is that you have a limited claims period. In Illinois, it's 6 months, in Iowa, it's 4 months. And basically what happens is you publish a notice to creditors after you probate the will, and then anybody who's got a claim against your estate has to file that claim within 6 months, or they're done. Okay? You publish a notice and you have to mail it to them as well. With a trust, you don't have that same statutory period. So let's take, for example, a situation where a person's involved in a fatal automobile collision and dies in the collision, and the driver of the other vehicle also dies. The other vehicle has a claim against the first person's estate because the first person, say, ran a stop sign and T-boned him or had a head-on collision or something of that sort. So there's a claim against the estate. And so the person who's died has a probate proceeding. They publish notice to creditors. They serve notice on the estate of this other person in the other car. If the person in the other car doesn't file a claim in 6 months, they're SOL. They don't get to file a claim. Whereas if you take that same situation and there's a trust, potentially the claim could be filed for up to 2 years because there's a 2-year statute of limitations on personal injury cases. So there is that advantage that it can put a little tighter limit on it. We've seen that happen with medical bills oftentimes. Sometimes hospitals are very slow getting their bills out. Ever heard of that before? Yeah. And we will serve notice on Genesis or Trinity and say, you know, there's this estate that has been opened, and if there are any claims, you have 6 months to file from the date of first publication. If they don't file within that 6-month period and they don't get their bill to you until 7 months and 2 days, then you can send them a letter back saying, well, we're sorry, but we provided you with notice and you'll just have to eat these claims because you didn't file it in a timely fashion. And that happens a lot of times, you'd be surprised. The same thing wouldn't be true, again, with the trust. So I'm not pushing either one. I'm just saying there are advantages and disadvantages either way, and you really have to pick something that suits your particular case, and that's where estate planning comes in, to figure out what really makes sense for you. Another reason a trust could make sense would be if, let's say, you had some situations within the family you really didn't want anybody to know about. And you were putting those in your trust instrument. Maybe one of the kids hadn't kept in touch over the years. And you really didn't want anyone to know about that fact, but you didn't want that particular child to get the same share that the other kids did because they haven't been in contact for 15 years. Well, you could put in your trust instrument words to that effect and nobody would know about it. With a will, on the other hand, the will is lodged with the court and that information is going to be available to anybody who looks at it. So that can be an advantage with trust, is to keep some level of confidentiality. And another advantage for trust can be if there's someone that during your lifetime, well, did you think you might have an illness that might require someone managing your property for you, or your spouse might have some difficulty managing property? A trust can be a useful tool for that as well. Although some of those things can be addressed by a power of attorney, which we'll come to in just a second. So that's an earful. Any questions on that? We just come on for air for a second. Yeah.
I always thought that in order to have a trust, you had to have a certain amount of money in your...
No.
No. Okay.
No, trusts aren't governed by that. You can put any amount or as little as you want. What I find regrettable sometimes is people will set up trusts and they won't put anything in. And trust means nothing then. And this is one of the problems, that a trust and a will only cover assets that are in your name alone. In fact, let me just come to that. We've talked about wills, we've talked about trusts. One of the things I find really important increasingly to talk to people about are beneficiary designations. Because normally, well, let's just leave the trust out of it right now because that complicates things a little bit. Let's just talk about wills. Normally, your will is only going to cover an asset that's in your name alone and that has no beneficiary on it. Let me repeat that because that's a really important principle. Your will only covers property that's in your name alone and that has no beneficiary on it. Okay? Now, you might say, well, a lot of my property is in joint tenancy. What about that? Well, that's not, your will's not going to cover that, because the joint tenancy is going to say that property passes to your surviving joint tenant. Typical situation would be a husband and wife. You've got your house in joint tenancy. When one of you dies, it goes to the survivor, right? I mean, that's probably what you figured out when you did it. It doesn't pass under your will. It goes by joint tenancy to the survivor. Now, the survivor has it in their name alone. Their will cover that. Okay? You follow that? So it has to be in your name alone, without anybody else on it, no joint owners, and with no beneficiary. What about beneficiaries? Let's talk a little bit about that. A beneficiary, you've probably heard of POD or TOD accounts, transferable on death or payable on death accounts at the bank. Those things are going to pass to whoever your named beneficiary is. They're not going to be covered by your will. Okay? Unless the beneficiary dies before you, of course. But if it was, for example, your kids, they're probably going to outlive you, and if that's the case, that's going to pass to them by means of the payable on death or transferable on death. Your will won't affect it. Okay? Now, where does this get to be a problem? Well, let's suppose you have a will, it could be a trust for that matter, where you had left a portion of your estate to Trinity Lutheran Church. Okay? Let's say 5% of your estate to Trinity Lutheran Church, or to Augustana College, or to, you name the charity of your choice. And let's say all of your assets are in joint tenancy or have named beneficiaries on them. Okay? Your kids, let's say, or your spouse or whatever. None of that property is going to go to Trinity. Why? Because it's all going to the beneficiary. Okay? So you have to, as part of estate planning, kind of look carefully at all your assets and see, now, what do we have a beneficiary on and what don't we have a beneficiary on? Because if you have a beneficiary on it, and it's not your estate, it's going to bypass your will. And that's not going to wind up going there. Okay? Now, sometimes you can tie the two together. We had a case a little while back with a woman who had never married, had no children, and wanted to leave a large part of her estate to charities. And so she set it out in her will what she was going to do. Well, one of her beneficiaries was a church, and we used as the designated beneficiary on one of her IRAs the church. And so there, it did go to the charity. But generally, if you have a will, the only property that's going to pass under your will is the property that's in your name alone with no beneficiary on it. Okay? Now, I've repeated that several times. I don't want to beat a dead horse. But it's really important that you look at your assets to see how you've got them set up, to figure out what your will is going to cover and what it's not going to cover. Okay? Yes?
Well, I had a question. Was my understanding that if you had a trust, and you also had a will, that the will would not have to be probated if the things that were in the will were less than $50,000.
$100,000.
$100,000.
Yeah, that's generally true. The only problem with that is that you can get into some issues if your will left property to multiple individuals, and if there are any bills that need to be paid. Because normally the bills would be paid out of the estate, and one of the prices, it's called a small estates affidavit. If it's under $100,000, you can use a small estates affidavit. But it really works best where it's a very simple estate with, say, a single beneficiary and the bills have been taken care of. Because otherwise, one of the things the person signing that affidavit says is that all the bills have been paid. And Mr. Bank, when you give me the CD that was in my aunt's name, I can take it free and clear because I'm her only beneficiary. I'll take care of the bills. If the bills don't get paid, she could be sued. Okay? So you can undertake personal liability with a small estates affidavit. But yes, generally, if you're under $100,000 and it's a simple, very simple estate plan, you can probably get by without having to do any kind of probate. Again, if you're using a trust, though, you probably should have most of your assets in the trust. That's the whole purpose for it. So if you're using a trust, you really need to make sure you get most of your assets in there. Yeah.
Since almost everything seems to want to identify beneficiaries, and one does that, it could mean then that the will covers almost nothing.
Exactly.
Is that right?
Exactly. And that happens. Now, that creates some issues in terms of payment of bills and expenses. Usually under trust, there will be a provision for covering that. But let's suppose you had a situation where you had a person who had a bunch of medical bills and they decided they were going to try to bypass that by putting a POD on all their bank, they had all their assets in bank accounts and they put a POD on all those assets so that it would go straight to Johnny or Susie, their two kids, and bypass the creditors. Well, now you got a potential litigation on your hands because the hospital may file a claim against the two beneficiaries alleging that the transfer and the POD was intended to defraud them of their claims. So there can be some catches with that. And I usually like to suggest that when a person passes that they provide enough liquidity to cover those bills so they don't unwittingly bring their loved ones into a lawsuit because the property passed outside of it. But yeah, you could have a safe situation. It's not terribly uncommon that people will do that and they won't realize what they've done. And then you'll say, well, you do know because you've got beneficiaries and everything and your will isn't going to touch any of this. No, I didn't know that. I thought my will would cover everything. No, it only covers assets that don't have a beneficiary. I hope that wasn't the passing bell. Okay, yes.
Collection plate.
Mark, would you explain probate?
I'm sorry?
Please explain.
Oh, explain probate.
Probate.
Yeah, that's what probate is it's basically the process by means of which the will, or the court acknowledges a will as being the valid will of an individual. In the long and short of it, that's what it is. The court says, this is Joe Blow's last will and testament. And it will be given effect. And then they will appoint whoever you named as executor as the executor to manage those affairs. An example of what probate would do would be, do you all remember Howard Hughes? Maybe not personally. But you remember of him. When he died, I think he had 25 wills that he left behind.
Wow.
And a number of states, including Nevada and Texas and a few others, were fighting for the right to claim he was a resident of that state and that their will was his last will because they wanted to lay claim to the inheritance taxes of the past as a result of his death. And so there was a question for the probate courts of actually a couple of states, which is the valid last will and testament. And so that's what probate is. It's to determine what's the valid last will and testament. And there are certain rules the court has to follow in probating a will. Was the will validly executed? Was it validly drawn? Was it the original of the will? You remember I mentioned before that only the original can be admitted to probate. Was it the original of the will? And those sorts of things. And that's what probate does. And then the probate court generally maintains a loose level of supervision over the proceeding. In Illinois, it's pretty loose because we have what's called independent administration until the very end. When you come back to the court and you report what you've done, you give a final report to the court, and the court says, executor, you've done your work properly, you're discharged from further duties, and the estate can be closed. It's basically a means of making sure that what the person, the decedent intended, the deceased person intended, is given effect by the court, and it's properly issued. But we have this independent administration in Illinois that kind of presupposes that if the decedent named, if Joe Blow named Jack Smith as his executor, he knew what he was doing, and we don't need to look over Jack Smith's shoulder to make sure of it. And so that's where independent administration comes in. And that's presumed in Illinois unless someone objects to it. Now, if there's a dispute between family members, then you might have supervised administration, which is more like Iowa. But it's, that's the way it works, okay? That's what probate is.
Thanks.
Okay, let's talk about a couple of other things. Just a word on joint tenancy. Works best between husbands and wives, not a good idea between parents and children. An old story goes way back. Before I started practicing law, since almost antediluvian now, but before I started practicing law, my dad had a client who had recently lost his wife, and he had one daughter. And one day this fellow came in the office and he had coffee with a bunch of his friends, and they said, you know, if you use joint tenancy, you can avoid probate. So this fellow came in and said, is that true, Lloyd? Can you avoid probate if you use joint tenancy? And he said, yes, you can, but let me give you a few problems with joint tenancy between you and your daughter. He said, if you put this property in joint tenancy with your daughter, she's going to be a co-owner of that asset right now. And if you ever have a falling out with your daughter, she's going to be entitled to half of it. And he said, oh, that'll never happen. Julie and I are like this. 2 years later, he's back in the office again. And he just had lunch with Julie, where he's given her the glad tidings that he has met a woman who is the new love of his life. He is planning on remarrying. By the way, he'd like to have those assets that he put in joint tenancy given back so he can make appropriate provision for his new wife. And Julie essentially tells him, over my dead body. It wasn't pretty. And Dad, without wanting to say I told you so, basically said, we did review this a couple of years ago before you decided to do this. He said, well, what can I do now? I said, well, you can go through a partition proceeding, and that's a legal proceeding to have the assets split in half. And Julie's going to get her inheritance early. So that's a problem with joint tenancy. The other problem is that sometimes people will use joint tenancy as a way of making sure that someone can take care of their property during their lifetime for them. I had a case a couple of years ago involving a woman who had 3 daughters, and she had a will that left all the property to the 3 daughters in equal 1/3. Logical thing to do. She then passed away, and the 3 daughters came in the office. Well, one of the daughters, who was the one that was local and helped her mom through all her difficulties towards the end of her life, kept track of what was going on. And so I turned to her and I said, well, now tell me what your mom had when she passed away. And she said, well, she didn't have any real estate. Most of her property was in CDs. Well, how much did she have in CDs? About $300,000. Okay, and how were those set up? She said, well, they were all in joint tenancy. Okay, joint tenants. Well, Mom and me, because the person at the bank told me that'd be a good way of avoiding probate and making sure that I could keep paying the bills and taking care of everything. I said, well, it's all yours now. Because it was. Through joint tenancy, 100% of that property went to the one daughter. Well, the other 2 daughters, particularly the one in the corner of the library who hadn't taken any particular interest in her mom for years, but now was there, the kind of. You could see the smoke coming out of her ears, too. And, she felt like she had just been snookered out of her share of the estate. Well, fortunately, the daughter who had received the property by joint tenancy was a good kid and said, I know what Mom intended, and I'm going to make sure that the other 2 get their share. But we had to file gift tax returns. She had to make a $100,000 gift to each of her 2 sisters in order to get that out, because it was all her property at that point. So joint tenancy is best between husbands and wives. Be used very carefully between other family members, because you can have the old law of unintended consequences can come home with a vengeance on it. Let's talk about a couple of other things. We've talked about mostly things that would happen upon death, but I always feel that it's important to talk equally, or at least fairly equally, about things that might happen during your lifetime. A terribly valuable instrument for everybody to have is a power of attorney. And another instrument, assuming it suits your tastes and intentions, is a living will. Power of attorney. What is a power of attorney? Power of attorney is a direction that gives somebody the authority to act for you during your lifetime if you're not able to do so. Powers of attorney generally are broken down into healthcare powers of attorney and property management powers of attorney. Healthcare powers of attorney are things that give someone the authority to act on your behalf as it may relate to your physical well-being. It could be anything from surgery to convalescent care to nursing home to getting you to the doctor on time, or answering questions if you were injured in an automobile collision and were temporarily incapacitated. That's what a power of attorney can do for healthcare. Property management, logically, would be paying the bills and making sure that if convalescent care was needed, it was paid for. If there was an unpaid balance on a medical bill that wasn't covered by insurance, it was taken care of. These can be put into a single instrument, and we frequently do, consolidate the 2, in a healthcare and property management power of attorney. They also could be made conditional, so that the power of attorney will only go into effect in the event that your doctor certified you were disabled. Sometimes when parents they might both be having some health issues, and so they're naming one or more of their children as powers of attorney. They might want to put that in there so Johnny or Susie doesn't jump the gun and start using the power of attorney too soon. And so that can be done. It can be made a conditional power of attorney. In terms of who you pick, it should be someone who you trust implicitly to make those kinds of decisions. Now you can name more than one, but only one at a time. At least that's the way we do it. Some will name joint powers of attorney. Under the most recent enactments of the Illinois Power of Attorney Act, you cannot do that, and we haven't done that for years, for the simple reason that you need to have someone who can make the decision. And if there's a healthcare emergency and you've got two people, particularly two people who are very close to you that are called upon to make the decision and they disagree, what are you going to do? Go to court? Not the most efficient method of getting the answer you need. So, one at a time, but you can have a first choice, second choice, third choice. You can name as many choices as you want. Usually we suggest at least a first and second and possibly a third choice in case the first choice person can't do it. This might happen with an older couple where they name each other as their first choice, but when the time comes, both of them are somewhat incapacitated, and so you move straight to the second choice, which might be one of the kids, or a nephew or niece, or someone else they trust. Now, it can be, excuse me, go ahead.
Are the hospitals required to do this now with patients?
They're required to ask you if you have one. And they're required to offer you one if you don't have one. But let's just say, I've seen a number of their forms and I'm not wild about it. Because they, too often they kind of, the forms I've seen, and you know, there are others out there that may be fine, kind of meld the ideas of powers of attorney and living wills together. And they're different instruments with different purposes and different execution requirements. I don't generally suggest doing that, but they do have to ask you now.
Well, they ask and they say, well, where is it? And we have it at the doctor's, the hospital, everywhere we go, so.
Yeah, and that's what you should do. And powers of attorney you don't necessarily need to give to your doctor right away unless you're going to have some surgical procedure, so they need to know who the responsible decision maker would be. But as far as the living will, the doctor has to have a copy of that. And let's just touch on that. The living will is the other instrument that we always review with people. A living will is a document that says, this has a very limited application. It's really very limited, but it could be very critical. It says, if I'm ever in a situation where death's imminent and there's no chance of recovery, Doc, I want you to pull the plug. Basically, that's what it says. It doesn't use those words, but that's basically what it says.
DNR, do not resuscitate.
Well, that's a little different. We'll come to that in a second.
Okay.
But for me, the poster child on living wills was the Terry Schiavo case. Do you remember that case a few years ago down in Florida? The unfortunate young woman who was in a chronic vegetative state, on artificial life support, and there was a terrible row between her husband and her parents as to whether she intended to have a living will. Her husband claimed she didn't need to have it. Her parents claimed she didn't. Her parents claimed she was still alive and exercising cognitive function. Her husband claimed she was brain dead. The legislature in Florida, the governor in Florida, the Congress, President Bush, they all got involved in this. And finally, the Supreme Court of Florida weighed in and said, husband gets to decide. And so they pulled the plug, and when they did an autopsy, they found that, in fact, she had been brain dead, and the motor functions that her parents had observed that led them to think that she was still responding were just a little bit like the chicken with its head cut off, nervous twitching, and really nothing more than a very tragic case. But the whole thing revolved around the lack of a living will, because she never had signed a living will. So if there was ever a poster child for why you need a living will, it was Terry Schiavo's case. Because all that difficulty and dissension and discord could have been avoided if she'd signed a simple instrument that says, if I'm ever in a situation where death's imminent and there's no chance of recovery, pull the plug. Now you mentioned the DNR and, or a do not resuscitate, or a DNI, which is a do not intubate. We don't get involved with those normally. That would really be between you and your doctor because he knows more about your medical condition. A living will is something that's more of a legal document, if you want to put it that way, that's recognized by the law and that lawyers prepare. It's more generic in nature. It talks about general situation of whatever the cause may be. If death's imminent, there's no possibility of recovery. As far as DNRs or DNIs, those are things which really more relate to your particular case and something I would suggest discussing with your doctor, and he's probably got a suitable form for you. I had a case a few years ago with a fellow who had a severe pulmonary condition, and he had a DNI in place at the hospital and with his doctor that he didn't want to be intubated in the event that he had an episode. But those things really relate more to what you should discuss with your physician, given the nature of one's own particular condition. Okay. Now, with the living will, it's called a healthcare directive, which means it's a direction to your healthcare providers. On that, you want to make darn sure your healthcare providers have a copy of it. So you want to make photocopies of the living will and your primary care physician. And if you have any kind of secondary care physicians like an oncologist, a cardiologist, they should have a copy of it. If you're going into the hospital, as you mentioned, they'll ask you about that. They should get a copy of it then. Then it becomes part of your medical charts, and if the situation ever arose where the question came up, they would know. Okay? It also is a helpful instrument for the person under your power of attorney, because the healthcare power of attorney may be called upon to make a decision as to whether to, to pull the plug or not. And if you've got a living will in place, it helps them with that decision as well. But on a living will, the primary person who makes the call is the doctor. Okay? Yeah.
Do those need to be legal documents, or?
Yeah, oh yeah, there are formalities in signing them. And you have to have it witnessed by two people. And when you're dealing with something that's life and death, understandably, healthcare providers want to make sure that you have a proper form, because if you don't, and they act on it, and there are disgruntled relatives left behind, where that goes. Yes?
At an older age, is it wise to have a copy of this if you are traveling? Or what is involved when you're not where your caregiver is or your hospital that have that?
It becomes a little trickier. It's probably a good idea to take it, especially if you're doing a lot of traveling. It does depend on the state or government, national government, recognizing it. Most states in the Union would recognize a living will, as they would recognize a power of attorney as well, if that came to play. Let's say you were on a trip to Colorado, and you took a spill when you were going down the ski slope or something, and bumped your head, and needed the power of attorney to be in place. The power of attorney could be faxed or emailed out there, and they should recognize it because it was a valid power of attorney in the place where it was signed. Now, the living will can be a little trickier, because if the living will, if you were in a foreign country, for example, that didn't recognize them, a doctor may not honor it, but they typically would. Yeah. Yes.
For both of these, you could see situations where the same generation person, i.e. the spouse, could be listed. On the other hand, maybe the attachment between the spouse and her partner or his partner would be such. Who typically that you work with, do you usually go with a person of the same generation, like a spouse, or for either of these, or do you go to somebody who's a lot younger, who even in this emotional moment would just have to say, hey, Dad, Mom's not going to make it, and I got to make the call. You're emotionally attached. I got to make the call. What do most of your clients go with?
Most named spouses.
Same spouse.
In the first instance, most named spouse. Unless the spouse is severely disabled. I had some folks in the office last week where the wife had named the husband, but the husband has got pretty advanced dementia right now and is also going blind, tragically. It's a real sad situation. But we're changing her power of attorney to go straight to the boys. Now, there is a provision that says in the power of attorney that in the event that the first named person is disabled, you go automatically to the second named person. And what I've seen done in some instances where one of the spouses knows that they're really not up to the job, they will just sign a resignation, and then it will go to the second named person. But unless the spouse is disabled in some way, usually spouses will name each other and the kids, because it's figured that the spouse is closest in the situation should be given that deference. Yes?
Our son is a male nurse in ICU, and he's been there for going on 16 years. Would you say he's a good person to honor the living will?
He
You know
probably,
his life and death.
yeah, he might be a good person to name as your healthcare power of attorney. To get to something that Norm mentioned a minute ago, on the living will, the kids really don't have anything to do with that. I just mentioned that it can be instructive to them as to your wishes if they're called upon to make the decision under the power of attorney. But the living will is an instruction to your doctor. Should be a physician that's making that call. The living will. That's a document that says, Doc, if I'm ever in a situation where death's imminent, there's no chance of recovery, pull the plug. That's the living will. The power of attorney is the thing that would give your son, for example, after your wife perhaps, the authority to make health care decisions in general, which could be whether to have surgery performed or whether to go through the rehab for a knee replacement or whatever it might be. That would be more the place where your son would get involved. And he sounds like he'd be very well qualified with his experience as a nurse to do those kinds of decisions. You're lucky to have that. A lot of folks don't have that kind of in-house expertise. But the living will would probably be an MD. Okay? Yes?
I'm a little confused because if you are living in one state and the person or people you want to have power of attorney are living in another state, do you use the form for your state?
Yes.
So it doesn't
Yes.
matter where you live?
Yeah, it follows the maker is the easiest way of putting it. Where the maker lives, not the person who's receiving it.
Okay.
And can you have a power of attorney from out of state? That's a good question. Yeah, you can. Just like you can have an executor from out of state,
Right.
you know, to administer your affairs when you're gone. But just to sort of tie in this whole thing with what we were talking about before, power of attorney is a really important instrument. I won't say it's as important, but there's a comparable importance to the will. Because a power of attorney can save a huge amount of money. We had a situation a couple of years ago, the same fellow had a pulmonary problem, had children that just couldn't get along. And there was a dispute over who would be appointed guardian because he never had a power of attorney in place. And I think it was $25,000 later, we had that taken care of.
A waste of money.
Yeah, and it could have all been avoided with the power of attorney. But the kids couldn't agree, and there were disputes over, you know, did he need to do the DNR, DNI, didn't he need to do that? When was it in place, and who did what? It's just very, very nasty business both way around. With a power of attorney, you can avoid 99% of that. And so it's an extremely important instrument, and it really is during your lifetime, whereas the will only goes into effect after you're gone. Now, some might ask, well, what's the relationship of that revocable trust idea we talked about to a power of attorney? Well, they can be overlapping to some extent. Normally, if you set up a trust and you do it right and you put the property in the trust, the trustee is going to take care of the property decisions, okay? They're going to make that. But they won't take care of health care decisions because the trustee just manages property. So you'd still need to have the health care power of attorney. The property management power of attorney, if you had a trust in place, would really only cover property that wasn't in the trust. Does that make sense? Okay. If you put property in trust, it's governed by the trust. If you have property outside the trust, it's governed by your will, and it's governed by your power of attorney. Okay? I know this gets a little complicated.
Well, you said, you know, about the will being very important in this trust and then, so if something happened to both of you and you have it in a safe in your home, and then somebody should know about that because you said that you're responsible for having the
Right.
will, not the attorney's office.
Right. Yeah, and that's a good question. And what usually happens on that, what I'll usually suggest to people is that if they have a safety deposit box, keep it there because that's a safe place. If you have a safe at home, you can do that too. That's probably going to be pretty safe. But make sure there's somebody you can get at it. Now with the power of attorney, you have the power of attorney, they have the ability to get into the safety deposit box to get the will out if that's where you kept it. If it was in your home, of course they could get at it that way. And you should, I wouldn't, unless your power of attorney has a combination, I probably wouldn't put your power of attorney in the safe. Make sure your power of attorney has what they need should it happen. So if you have a power of attorney, you're going to have to give them some trust. And normally, if you don't have that trust, you don't want them to be your agent. Okay. All right? You with me? Okay. All right. Now, let's talk just a little bit. We've got just a few minutes left here about a few things in terms of what you would want to do if you were going to be getting an estate plan put in place. I've outlined the need for these different documents. We've talked a little bit about what they consist of. What I find helpful before someone comes in the office to see me about estate planning are the following. First of all, probably pretty obvious, who do you want your property to go to? You know, first choice, second choice, third choice. Now, who would you want to have things passed to? And that could be family members, it could be a charity, it could be charities, it could be a good friend. I've got one right now we're administering over in Iowa where she had no real close family, so she left everything to charities and friends. And who do you want it to go to? What if they're not around? Who would be the second choice? Who would get it then? And the third choice, if they were gone too. Because we're all mortal, and you know we never know who's going to outlive who. Who do you want to have take care of the property? Who's the executor supposed to be? Who would you trust to manage affairs? Okay, think about that again. First, second, and third choice. Okay.
Well, go ahead.
Go ahead.
Either way.
Go ahead.
Take your time.
Maybe you could, after you go, maybe you could talk about how to get other family members to face the reality that we are all going to pass away. Because I know recently, and it's hard in my family because my kids dad has been very ill for the past year, so they're kind of dealing with the mortality of both of
Sure.
their parents. And, but for me, recently, I brought this up with my kids, is that I do want a power of attorney, I want to draft it, and it's just because of things I've seen happen,
Sure.
that things can go terribly wrong instantaneously, and when you don't have anybody to make decisions for you, it's a mess. So anyway, so how do you get people to talk about this when you don't want to talk about
Yeah, and that might be addressed to some of the other speakers in this session. But one of the things I do find to be very useful, and we will always give to people when we do an estate plan, is it's called a personal information sheet. And on this sheet, people can describe, information about themselves. We have information about where, if they've made arrangements at a particular funeral home, particular cemetery, more and more prepaid funerals, and you probably heard about that in one of the other presentations in the series. You don't want to have that fall between the cracks and have them go to escrows when Whelan's was the one that was paid, or vice versa. So you want to do that. But then the other information it's got things about the funeral service, where should it be, who would the pastor be, what would the scripture passages and hymns, things that you have personal feelings about that you might not talk about over the dinner table. And then information regarding where to look for things. Where do you have your will? Where do you have your abstract, your title insurance on your house? Where do you have your bank accounts? So what tax deferred plans do you have? It's basically intended to be sort of a roadmap, is the term I use, a roadmap to tell them where to go and what to do and when to do it, and that sort of thing. Now that's after death. Before death, I think it's really more a matter of just finding an opportune moment to share with them. And it may simply be sharing with them, this is where you look if you need these instructions on this. But if it's pre-death, then you're going to have a conversation about who's going to be the power of attorney. I always suggest to people, you don't need to tell anybody they're going to be a beneficiary, but you better ask them if you're going to appoint them to take some responsibility to make sure they're willing to do it. So you need to have a conversation with one or more of your children about who you're naming and making sure they're willing to do it. Because you don't want to name two people and neither of them are willing. And they probably will be willing, but there's no way of saying that for certain, so you want to do that. Okay? I hope that's helpful. Otherwise, I defer to Pastor Conlon.
Oh, I was just going to ask about executors. Is it beneficial to have more than one, or should you only name one? Is it?
I prefer one at a time. No, I prefer one at a time.
Okay.
It's a little bit, it's not quite as problematic as it is with power of attorney because you're not dealing with life and death decisions. But I still think it's useful to have one at a time. Because if you have two, number one, you might be paying a double fee for both of them. Number two, if they don't get along, then you've got the issue of who decides whether to sell the house or
Everything
not.
else, okay.
So,
Makes sense.
but that's the other thing that I generally suggest people doing is not only thinking about who you want to leave things to and who you want to have be responsible during your life and after death, but also that you do a list of your assets, okay? And this is very important, and it's not just nosiness on the part of the lawyer, but it's very important because how can you do an estate plan without knowing what the estate consists of? It'd be like, I said to the first group, it'd be like hiring an architect to design a building for you without telling him its purpose. It's a little hard to do if you don't know the details. That's one reason. The second reason is to make sure that the will is going to be affecting something. I found in many instances when I go through assets with folks, I'll find that almost everything's got a beneficiary on it. And when we get to the end of the day, I'll tell them, your will's not going to really affect anything. You've already got these things set up. So if you want some of your money to go to a church or college or healthcare organization, you better have some money passing under your will or your trust. And then just to finish the thought, the other thing is to check on that and to review the amounts in each of the assets so we can determine if there are any tax or other questions with that. That list is useful not only in doing your plan, but you'd be surprised how many cases I've had of folks who will come in the office and they'll say, we don't know what mom or dad owned. And I'll say, well, I don't know for sure, but I can tell you that when we had our meeting in my office in January of 2014, their bank accounts were here, they had life insurance here and here, they had this other a tax-deferred account here and here. So I suggest you start looking in these locations. So it can be very useful in terms of trying to track things as well. Go ahead.
How often do you recommend that these things be reviewed with your?
I generally suggest about every 3 to 5 years,
Because things
Or if-
change constantly.
or if there's a major change. You know, for example, if a person lost a spouse, that's a good time to go over things. Because there are going to be some things that probably won't require probate, because most things will probably enjoy tenancy. But there may be some things that need to be reviewed to make sure the beneficiaries on insurance are changed. Let's say the deceased spouse had life insurance. Might be $100,000 in life insurance coming in. Where's that property going to go? What are you going to do with that? IRAs, 401ks, you need to roll those over to your own IRA, or you run the risk of it. You pulled it out, you could wind up having a big tax. So I suggest 3 to 5 years, or if there's a major life changing event.